Welcome to The Explainer. Today, we're unpacking a really fascinating and honestly deeply important tension. What actually happens when a scholar's online posts collide head-on with state power? We're going to objectively dissect the abstracted case of Dr. Chen Jingyuan. We'll be stepping back to analyze this event through both domestic and international legal frameworks to see exactly how they intersect with individual rights and, well, the very concept of justice itself. Okay, let's dive right into this. Where exactly is the line between academic expression and criminal behavior? It's the central hook of our analysis today. When a scholar shares thoughts, research, or even art online, at what precise point does that cross over into something a state can legally punish? As we go through the source material, we're going to break down the complex legal and philosophical boundaries that separate protected freedom from a punishable offense. Here's our roadmap for today. First, anatomy of a judicial event. Second, the constitutional law perspective. Third, civil and political rights. Fourth, academic and cultural freedoms. And finally, systemic risks and boundaries. Section 1. Anatomy of a judicial event. An academic on trial. According to our sources, a highly educated scholar was arrested and charged with offenses broadly categorized as picking quarrels and rumor-mongering. And the basis of these charges? Simply sharing online content, theoretical observations, and art, specifically things like an Umbrella Girl comic and various historical and philosophical materials. The authorities basically viewed this subjective online expression as a deliberate, malicious attempt to disrupt public order. Section 2. The constitutional law perspective, the domestic baseline. Article 33 of the Constitution explicitly states the state respects and preserves human rights. Now, this matters because human rights aren't just some abstract philosophical ideal here. They are a concrete state obligation. This clause sets the absolute baseline for evaluating any judicial or administrative action. Any state power has to operate within these boundaries of respecting human dignity. Now, what's really interesting is when we map these judicial actions against constitutional protections, clear tensions emerge. Think about it. Charging a scholar for sharing academic or artistic content potentially overexpands the criminal definition of an offense, which clashes directly with Article 35's freedom of speech. Furthermore, arbitrary arrests without transparent evidence. That raises major questions about Article 37's protection of personal freedom. And then there's Article 41, which guarantees the right to criticize state organs, meaning suppressing a scholar's public commentary directly conflicts with this constitutional right. At the core of this legal framework is a pretty simple logic. Freedom is the principle, and restriction is the exception. Citizen freedom is the default state of being. Because of that, any restriction imposed by the state requires strict, explicit legal justification. It literally cannot be arbitrary. It must be necessary, and it has to be proportional to an actual threat. If a scholar's online posts don't pose a real tangible threat to public order, restricting their freedom kind of flips this entire constitutional logic completely upside down. Section 3. Civil and political rights, the universal baseline. To really grasp international human rights law, we have to look at the proportionality principle. It basically dictates that any restriction on your rights must be strictly necessary, appropriate, and directly proportionate to the actual threat posed. Think of it this way. You wouldn't use a sledgehammer to swat a fly, right? International law requires a strict balance. The state's intervention must exactly match the actual proven harm. Let's move on and see how this builds. The ICCPR enforces this through a strict rule of three test that a state absolutely must pass to legally limit expression. Step 1, legality. Basically, is there a clear, foreseeable law? Step 2, legitimate aim. Does the restriction serve a valid purpose, like protecting public order? And Step 3, necessity and proportionality. Is it the least intrusive means possible? In the analysis of the Chen Jingyuan case, the sources argue that heavily penalizing academic and artistic expression fails this test, particularly Step 3, because criminalizing abstract online posts is, well, radically disproportionate to any perceived threat. Now, when that rule of 3 fails, we enter the territory of arbitrary detention. This is an arrest or detainment that is excessive, unnecessary, or disproportionate, even if it happens to have a formal legal basis. According to the source analysis, detaining an academic, interrogating them extensively, and holding them without a transparent, publicly tested evidence chain surrounding their online posts, that squarely fits this international legal definition of arbitrary detention. And this is all anchored by Article 1 of the UDHR, which states, all human beings are born free and equal in dignity and rights. This is a profound reminder that legal procedures should never, ever be weaponized for institutional humiliation. The law is meant to protect human dignity, not strip it away through disproportionate punitive measures against individuals simply for sharing ideas. Section 4. Academic and cultural freedoms. The scholar's shield. So the crucial point is this core tension. Cultural expression, we're talking things like art, philosophical debate, and academic exploration, is highly subjective and strongly protected. Criminal rumor, on the other hand, is an objective, deliberate falsehood meant to cause severe social panic. The legal sources argue that you absolutely cannot judge subjective artistic or philosophical expression by a binary metric of true or false. Conflating cultural expression with criminal rumor is, quite frankly, a severe misapplication of the law. Under ICCPR Article 15, there are some very specific core protections: the right to participate in cultural life, the freedom of scientific research, the protection of academic exploration, and freedom from political interference. What's particularly troubling in the source material is the prosecution's argument. They actually utilized the scholar's high education to presume subjective malice. The logic was essentially, because he has a PhD, he should have known better, therefore sharing this art was malicious. The legal analysis argues this directly contradicts these protections, effectively turning a scholar's academic background into a weapon used against them. Section 5. Systemic risks and boundaries. When procedures fail. And this brilliantly illustrates a bigger problem. What happens when procedures meant to protect rights actually hollow them out? We see indicators like a presumption of guilt over active investigation, using abstract labels like picking quarrels instead of concrete evidence of harm, a weakening of defense and appeal rights, and a dangerous methodology of first arrest, then gather evidence. The legal sources argue that when these indicators are present, it signifies a chain of procedural failures, from arrest all the way to appeal. The form of law exists, sure, but the substance of justice is completely hollowed out. Ultimately, laws must govern the state, not just the people. Across all the frameworks we explore today, the domestic constitution, the ICCPR, the ICCPR, the unifying purpose of the law is to keep human dignity above unchecked power. A true rule of law system restricts the government just as much, if not more, than it restricts its citizens. So that leaves us with one final thought. If legal procedures fail to protect the scholar, who protects the truth? When academic exploration and cultural expression are treated as criminal acts through blurred legal boundaries, the pursuit of knowledge itself is at risk. It's a tension that requires constant vigilance, strict adherence to proportionality, and a deep, deep respect for human dignity. Thank you for joining me to break down this complex legal anatomy. Keep questioning, keep learning, and I'll see you in the next explainer.